So good evening, everyone. We would like to welcome you to a panel-led revision I'm conducting with a few of my colleagues. So we have lawyer Gertrude Moko here. We also have lawyer Stanley Jamfi. You have Mr. Ezekiel. We have lawyer Kojobio Ejane, and Kokwenu Hussein will be joining us. So my colleagues who are here, Ezekiel, can we see you? Ezekiel, can
Hello, Doc.
Yes.
I'm here.
All right. Mr. Jamfi, can we see you?
Yeah, Doc, I'm here.
Okay. Mr. Kojo Ajebio. Mr. Bio.
Mr. Bio will be with you in a moment, Doc.
All right. Okay. Lawyer Gertrude Amoko, are you here? I didn't Lawyer Gertrude. Okay. All right. Dr. Anderson, are you here? Okay, so this is what we are going to do. We are going to create opportunity for you to ask questions, and then our panel will help you to address them. So maybe let's start from land law. So land law, are there any questions or challenges? Or maybe let me do it this way. Our panel members, if I mention the particular subject, then in your own view, things that you think students should pay attention to as far as that subject is concerned, maybe you give each panel member a few minutes to make opening remarks, and then we take it from there. But as far as I'm concerned, I'll be telling them a lot about what they should pay attention to. But let's also hear your views before we will go back to the students for them to also share their thought with that. So I don't know, Lawyer Jamfi, anything as far as land law is concerned, which you think that students preparing for this year's entrance examination should pay attention to? And then after
very well, thank you.
Lawyer Mr. Ezekiel, soon to be Lawyer Ezekiel.
Thank you very much, sir. For me, I believe that this year constitutional law will definitely be the area to watch. Even though they've been asking quite a lot of questions on local standard, I still believe that it's still relevant up to this day. And if students take it very seriously and learn all the rudiments of the local standard in the Supreme Court and the High Court in respect of human rights, I believe that it will inure to their benefit, such that at the end of the day, when the results come, they would be lucky enough, like the rest of us, to have an admission into the Ghana School of Law. So for me, I think that constitutional law are a cause to watch out for. Thank you, sir.
So constitutional law, do you have any particular themes or areas you think?
Okay, as I indicated earlier, the local standard in the Supreme Court is the area that I tip. So how to invoke the original jurisdiction of the Supreme Court under Article 2 and 130 vis-a-vis the human rights enforcement in the High Court. Because I remember quite distinctly that when we went to level 100 in 2014, the then dean of KNUST, Professor Inkansa, told us that that was the question that came that very year, 2014. So I told my colleagues right from that point that this is a question that will come in our time. In our time, we solved it, but unfortunately, when we went, it didn't come. But our paper was cancelled. When the paper was cancelled, the one we retook is the Supreme Court local standard that came. So for me, that question, I have strong feeling that it's likely to come.
All right. Okay, thank you, Mr. Jamfi. We come back to you. Mr. Ezekiel was saying.
Hello, mentor.
Yes. Any thoughts or suggestions which students should pay attention to, the subject areas?
Oh, right. I think that for constitutional law, we all know that for the past 5 years or 6 years, almost every year they bring a question on constitutional law. For me, as it stands now, I'm not in the spirit to know whether this is the particular topic that is going to come, but I have a strong feeling that if there should be any one cause that they can be sure about this year, if anything doesn't change, they can be sure about getting the question from constitutional law, given the trend of how they do their things these days. Because for the past 6 years, almost every year, they try and then bring something on constitutional law. And in terms of areas, maybe to add to what Lawyer Stanley just indicated, probably they can look at the chieftaincy jurisdiction of the court and all that, about the whole thing about chieftaincy, and then the jurisdiction of the court as to whether the high court and then the other court have jurisdiction when it comes to causes or matters affecting chieftaincy. Those are the few things that I think that if there should be any constitutional law question, probably they can raise it up. And also questions about this judicial review and also emerging trends that have been going on, LGBT and its constitutional implications. So I think those are the things that probably they should avert their minds to because of what we've seen before. Yes. So these will be the few things I will say for now. Thank you.
Okay. All right. Thank you, Mr. Ezekiel. Lawyer Bio, are you here?
Yes, Doc, I'm here, sir.
Good. So we are taking initial thoughts on areas that you think students should include in their revision if they've not included so far. I don't know if you have any areas you may want to share with them.
Yes. Look, briefly, I think that's something on emergency powers, particularly on security of the state, particularly Articles 31 and 32. Earlier this year, there were some security issues, which I think that probably a question can be framed around that area on evocation of these emergency powers or the declaration of security of the state.
State of emergency.
Yes, and also on the constitutionality of some customary practices. Of late, there's been talks about some of these customary practices. Not long ago, I think and the Benshia issues, the homo, the gun chiefs, and other matters. So I think that's something to on the constitutionality of some customary practices may also come or say can be an area to be looked at by the students. Yeah. So generally, as the case said, this is also like a chieftaincy too, chieftaincy, and then the constitutionality of some of these customary practices, plus emergency powers. Yes.
Okay, let's say, is that a consideration of certain customary practices? What customary practices are you alluding to?
By saying that, looking at the ODK scenario, and then particularly on also the ban on drumming and noise making. I saw a question from Youth PSC where they were giving some facts suggesting that they should address some constitutional issues within customary settings. You know, per Article 26(2) of the Constitution, customary practices are allowed to the extent that they are not dehumanizing. So, per the facts I read, a question was given, and in there, the students were asked to raise some constitutional issues within those facts given. So I think that this year, looking at some of the topical issues that have come up this year, I think that something on customary practices, customary law may also come, plus chieftaincy, yes, and also emergency powers, yes.
Oh, thank you, Mr. Bill. Lawyer Gertrude, are you here? Okay, Dr. Anderson? Okay, I'm sure they'll join us later. Okay, now moving away from constitutional law. Apart from constitutional law, let's come to criminal law. Criminal law appears not to have been examined for quite some time. So panelists, are there any areas that you think that students preparing will need to pay attention to as far as criminal law is concerned? Yes, Mr. Jamfi, then Mr. Ezekiel Osei, and then Mr. Bill, in that order.
Very well, Doc. For me, when it comes to criminal law, usually the sexual offenses are the areas that they usually look out for. But for me, I would also suggest that they look at armed robbery as well. Armed robbery, and especially the plea bargain. The plea bargaining act, which has been passed recently. It's one area that they don't have to forget. So sentencing and plea bargain, at least one might dovetail into the other. Sentencing and plea bargain, sexual offenses. That's what I think will be the likely areas if they are to set questions on that. Thank you, sir.
All right, thank you, Mr. Bill. So plea bargaining, is there any particular aspect and also the sexual offenses?
Doc, as we delve deeper into the discussion, we'll go into that. Hello, Doc.
Yes.
I'm saying as we delve deeper into the discussion, we'll go into that because we have Adjoa Samuel's presentation to start with. It covers essentially everything there is to know about the Plea Bargaining Act. And it's just a short PowerPoint presentation. So I'm sure we'll go into it, Doc.
All right, thank you. Mr. Ezekiel Osei.
Doc, I don't have much to say when it comes to criminal law, but I will side with everything that my seniors say in this regard. Thank you.
Mr. Bill.
Look, I also think that the inchoate offenses, they can also look at that because I think 2015, there was a question, and then there were some inchoate offenses in there too. So similar, I think that they can again look at it. Yes.
All right, thank you, Mr. Bill. So I'm going to open it up to probably let's go to the other areas of the law. What about the Ghana legal system? Are there any areas panelists would like to comment? Mr. Jamfi, Mr. Ezekiel Osei, and then Mr. Bill.
in respect of the Ghana legal system, and since there are just two questions, I am sure if they don't have one problem question or another essay question. So the essay question, if it comes to Ghana legal system, I'm tipping the introductory part of Ghana legal system, the introduction of equity, common law, those ones, those are the areas that I take.
Mr. Chike, can we hear you again?
I'm saying that when it comes to Ghana legal system, I'm looking at the history behind the common law and the equitable principles. Mainly about the introduction, the reasons why equity came into the history at the early part, because previously when you look at the objective questions, they had series almost every year, they were recurrent. So if it's suggestive that it's an area that they are very much interested in, and it's an area that they have particular interest at. So if they will look at that area too, I believe that it will inure to their benefits.
Oh, all right. Thank you, Lawyer Tiki. And just to probably add a bit of emphasis to what you have said, I was telling my students yesterday, when we met in person or either some of the people to online, that in preparing for these exams, you don't have to ignore the simple things or like the basic things.
Yes.
Because if you look at the trend of the questions, one can argue that the examiners know very well that you're going through the LLB and all that, and some of the subjects that have been examined are either the first year or the second year, few cases, third year LLB courses, and for that matter, you learned them long time ago and so on and so forth. And maybe some seemingly simple or elementary aspects or some of these courses, like what Mr. Jempi has suggested, you may ignore them and just worry your head about only the big things. And then you go and these seemingly simple elementary things are there. Yeah, so I perfectly agree that we should be guided by those seemingly simple things as well. Yes.
Doc, to add to it, I was telling some of our students in Presby that it will be very painful to go to the exam knowing very well that this is a very simple question, but you can't answer because you ignored all those basic ones. So that is very much true.
Yeah. Yes. You are right. You're right. Just like somebody said that you see the thing and then the person will be just no.
Yes.
No, but you see it as if like you know, but you don't know really what to know, how to go about it. Yes, Mr. Ezekiel, sir, anything with respect to Ghana legal system?
So I first of all, I side with what my senior just said, Lawyer Stanley just indicated. The basic things are very, very important. And to add to what he was saying, just like 2019, they had a very question on sources of law, which I think that many people may not have probably thought that they can bring sources of law, even though it was within a particular context and they were expecting them to do a lot of things in that regard. Now, in addition to the introductory aspect, what I think that student or prospective entrance exams writers should consider is when it comes to the jurisdiction of the court. That is, I think, something that they should also take into account, the jurisdiction of the court in Ghana. Starting from the Supreme Court, the various legs of its jurisdictions, the Court of Appeal, the High Court, and all that. And some aspect of Ghana legal system, you will realize that it also has constitutional law implications. So those areas that are one way or the other connected to constitutional law, I also advise that they take them very, very much serious. For instance, we were taught independent constitutional bodies and the Ghana legal system. Then when you come to constitutional law, we were taught the same kind of topic under constitutional law. So I think that those areas are some areas that I think it can go both ways as either Ghana legal system questions or constitutional law questions. So they should watch out for them. Outside that, I think that they should pay attention to the jurisdiction of the court in Ghana or the court system, if I should say so. Thank you.
All right, thank you very much. Mr. Kojoje Bio, Mr. Bio.
Yes, Doc. I readily support what Ezekiel just said. And to add to that, I also suggest that we also look at some of the alternative dispute resolution mechanisms within Ghana legal systems, because in the syllabus we have to teach that, and I think that it's they have some examinable areas there, particularly customary arbitration too. Customary arbitration. So they should look at the ADR processes, and then also particularly customary arbitration. I think these are likely some areas that they should look at. Thank you.
All right, you move from Ghana legal system and come to land law. So panelists, as far as land law is concerned, any area you like to direct the minds of students as they prefer? Land law. So TK. Mr. Jamfi, are you there?
Yes, sir.
Yes.
Doc, I said in respect of land law, I believe that Sir Dennis's inaugural lecture on Act 1029 does justice, and Act 1036 does justice to all there is to know about land law. So I'm sure as of now, if you've not summarized it, try and get a summary of it. It will give you all the new areas of our law concerning land law. So that article or inaugural lecture is perfect for any discussion on land law.
Okay, right. Thank you. Mr. Ezekiel was saying, any suggestions as far as?
All right, Doc.
Yes.
For me, I don't know, but I don't have a very strong, I have the strong feeling that land law may not come, but just to say something about it. Yes, I have a strong feeling it may not come, and I'm saying that.
Why do you have a strong feeling that land law will not come?
I just don't know, but I think so, probably because of the fact that the act that has come to replace most of the legislation that were regulating lands as it then came in not long ago. So I'm not expecting that examiners will try and then bring questions around that area. But outside that, I think that first of all, as Lawyer TK rightly said, the inaugural lecture that Sir Dennis J gave, that one gives an exegesis on the various changes that the Lands Act has made to various existing principles regarding land transactions in Ghana and all that. And I think that they should read that one. And beyond that one too, they should look at some of the basic interests in land and the incidents. So for instance, you look at the allodia title, the usufructuary interest, the freehold interest, among other interests in land. What are the incidents of it? What are the rights that are tied to those particular interests in land? And also the statutory interventions or statutory inroads when it comes to the enjoyment of these various interests in land are basic things that I think that they should have bear their mind to, because you would realize that sometimes the Constitution may bring certain constitutional inroads as to somebody's right over the land in question. Even statute may also do the same thing. You pick, for instance, the Minerals and Mining Act and all that. There are a lot of provisions in there whereby when you owe a land, they can say that land belongs to the state because of the fact that there's a mineral resource in it, which is in its natural state and all that. So they should look at all those statutes that makes inroads into the various interests in land that is can be applied under the Lands Act. So basically, that's what I would say when it comes to land law. And also the topic of leases, I think is something that they can also bear their minds to. Yes, thank you.
Okay, Mr. Ezekiel, I think I agree with all that you have said, except one thing you said, that you are not sure there'll be question on land law. As a
That
no,
one,
and I don't agree.
I'm thinking in my personal capacity.
I know, I know you've not entered the
Not as a
script yet.
panel.
Yes, because
I've not entered the script yet.
I tell students that we don't have any clue as to what will be examined and what will not be examined. We are only using experience and observation of what they have been examined and what is going on to give some suggestions. But we usually register a disclaimer that we haven't made absolute claim that this particular topic or this question is going to come. No, none of us, none of the panelists will hold that view. So students be guided by our disclaimer. So thank you, Mr. Ezekiel. Mr.
Thank you, sir.
Bill, Mr. Bill.
Doc,
Yes,
Doc,
any suggestion as far as land law is concerned?
I don't know if Ezekiel is aware. In 2016, there was a land law question on alienation of stool land.
Okay.
So, to my mind, I think land law is also a good examinable area. So students should also pay attention to that. Now, some concepts have been given, or they have some statutory notoriety. For instance, customary law of freehold, statutory interest, and then common law of freehold. There was some confusion, but then now with the act, with the passage of Act 1030, our act has given notoriety to all these concepts. So I think students should pay particular attention to the statutory inroads made in respect of these interests that can be acquired. Also, on the capacity to maintain an action in land matters, capacity to maintain an action in land matters. So in respect of family property, or say family land, who can maintain an action in respect of family property. Similarly, in respect of stool property, who can maintain an action in respect of stool property. So I think that these are example areas that students can look into. Thank you, Doc.
All right. Thank you very much. Students who have been following me know what my suggestions are as far as landlord is concerned. So I'll not belabor what I've told them already. Thank you, Mr. Bio. Now we come to, I think, the law of contract, and then after that, then we go to torts. So law of contracts. Are there any particular areas or topics that panelists will suggest as being what students should address their minds to? We start from Mr. Stanley Tribo, could be a jump fit. Let's take it.
Sir, when it comes to the law of contracts, it's one of the favorites of examiners because it's one of the building blocks of law. And for me, I would advise that students look at breach, damages, consideration, because consideration is one of the favorites. Breach, damages, consideration. Privity, I'm sure when privity comes, everybody can do because it's a very short topic. It's a very short topic. So, but for me, I think that the areas that I've just indicated, consideration, breach, and damages.
Okay, so you mean like the discharge by breach, and then
That is so.
Damages as a remedy for breach, and consideration.
Yeah, and one more. I've forgotten this Newman stuff.
Yeah, that's still damages. Remoteness of damages.
The remoteness, yeah,
of damages. Yeah, the
remoteness
measure of damages. Yeah.
Yeah.
All right, Hadley and Basindale.
Yes, sir. Yes.
Victoria Nimon Industry. All right. Okay. Okay. Thank you. So, Mr. Ezekiel was saying, are there any suggestions in terms of what students should look at in case they've not looked at so far in their revision as far as law of contract is concerned?
I have just one suggestion, Doc, for frustration of contracts.
Frustration of contract. Okay.
Yes, Doc.
Okay. Okay. Frustration of contract generally, or some aspect of frustration of contract?
Right. So I think if there should be any question on, if there's going to be any question on frustration, I think it can be in two forms. Typically, there will be the one that covers like a problem-based question, and then the other one that is like an essay question. So for me, in terms of the frustration, they should look at all angles of it. They should look at the common law position as it existed, and how even the Ghanaian Act, that is the Contract Act 1960, Act 25, has sort of modified the common law position as regarding the consequences of frustrated contract. And then also, they should also look at the difference between frustration of contract and then what you call like the force majeure circumstances, because they are not the same like that. So they should look at that one as well. Yeah, so everything that is related to it, they should look at it. Thank you.
All right. Okay. Thank you. Yeah. So where there's a force majeure clause, students, as you remember, then the doctrine of frustration will not apply, because force majeure clause has anticipated certain eventualities and so on, which may affect performance of the contract. For that matter, the default common law doctrine, as modified under Act 25 on frustration, will certainly not apply once you have a force majeure clause. In absence of force majeure clause, if you can bring yourself within that, that will apply. So thank you, Mr. Ezekiel Osei. Mr. Bill, any suggestions as far as contract is concerned?
Though for contract law, I think they should just go ahead and study everything, because for contract, everything is examinable.
Okay.
For contract, one thing links to the other. So I think for contract law is an area that they should thoroughly master, because everything can just come. Everything can come. So I think for contract, I have nothing to add except to say that.
Yeah. Okay. Thank you, Mr. Kojo JBO. So saying that for contract, he is one subject he says is too risky for you to exclude an aspect and include an aspect, because from introduction to contracts, what is contract, why contract is enforceable, through to publishing of contract, distinction between offer, invitation to treat, acceptance, intention, capacity to contract, consideration, terms of contract, exclusion clauses, vitiating factors, mistake misrepresentation, duress, undue influence, privity of contract, discharge of contract, and then remedies for breach of contract, all have equal chances of what? Of coming. So he wouldn't take the risk of saying that ignore this topic and read this topic in contract, but look at everything. Okay, thank you. Now, finally, we come to law of tort before we will come to the students for them to raise their issues, and then we deal with them. So law is, lawyer Gertrude, are you here? Okay, she's not joining us yet. Law of torts. And the last year, I think there was a question on torts. Are there some areas in torts if students have not addressed their mind, you like them to consider? Yes, Lawyer Jamfin.
Doc, I'd like them to look at defamation. Defamation as a topic in torts, occupiers' liability, negligence, especially when it comes to the psychological aspects. Those are the areas that I'd like them to focus on. That is not to say that you don't master them, but at least you look at these areas with very keen eye. Occupiers liability. The reason I say occupiers liability and defamation is because of the era that we find ourselves. There's a lot of issue about defamation, occupiers liability, and all those things, negligence. So those areas I think will be very hot kicks. And negligence, for instance.
Panelists, yeah, go ahead, Mr. Jamfi.
Yeah, so negligence is one area that is very broad. I think is the broadest topic in torts. So they should look at all the multifaceted areas of negligence. Defamation is also another area, and they shouldn't, as we are talking about the building blocks, they shouldn't forget the initial ones: assault, battery, because the tendency to neglect those ones as too basic, it will be there. But they shouldn't forget those ones, because as indicated earlier, it will be very painful to see a question that is very easy, yet you can't answer. You'll be clicking your fingers, biting your tongue. So they should look at those areas as well.
Okay. All right.
Thank you, sir.
Thank you, Mr. Jamfi. Mr. Ezekiel say, law of torts, any suggestions?
I stand with what my senior said, defamation, and if probably I may add nuisance and the rule in Rowlands and Fletcher. Yes.
Okay. Mr. Kojo Ejobio.
Doc, before I speak, I issue a big disclaimer before I say this thing. But however, I think tort law has thoroughly been examined for quite some time now. So this year, to my mind, alone, I think that for tort, something may not pop up on tort. But however, if they are to look at anything, defamation and the nuisance,
you see,
may come. But
okay.
This year.
Mr. Vio, and also just to our students or candidates audience. You see, I come from a very old school or conservative viewpoint that I look at your entrance examination as being operated on this system, that those who manage the system, I may be wrong, but these are my own, as somebody would say, educated guess or speculation, that they have like a pool of questions which are probably be set many years ago or whatever. They are out there, and even those who set the questions don't know which questions are coming, because maybe this took place about 3 to 4 years ago or whatever, and they are there. So therefore, in terms of the probability of any particular subject area out of the 6 subjects being examined on, I think we've lost something. Yeah, sorry, there was a internet interruption, sorry. Yeah, so I was making the point that if you assume that those who manage the exams, they have a pool of questions, predetermined, and all that they have to do is to try and pull out of those pool, then we cannot have the luxury of saying that maybe this particular subject will come or that will not come. So you have to give like an equal attention to all. And once you know all the topics, the 6 subject area, then the question cannot come outside these 6 subject areas. You will definitely be well prepared. And as I keep on also telling students that the next thing to do is now practice how to write answers to essay question and problem-based question. So thank you very much, panelists. So having made these opening remarks, We are now going to the students for them to raise issues and concerns so that my panelists will help them to address them. So if you want to raise an issue, raise up your hand. And you notice that if you don't control your mic and you let your background noise come into the class, we just remove you from the class. As you notice, I've removed someone already because the person's background noise was coming into the class. So if you don't want to be removed, then make sure that if you are not talking, you mute yourself. Thank you very much. Okay, so the person whose hand is up, Shanga. Yeah, Shanga, you can now.
All right, sir. So if the question demands that you write a memo, please, how do you go about it?
Okay, so we take about 3 questions and then we deal with them at a time. If a question demands that you write a memo, how do you go about it? Okay, good. Any other person? Any other? Let me see if there's any hand up. Okay, so next we have George Nasoa and then George Anambintum will come before we take Mabel and we address them. Georgina.
Thank you, sir. Please, I wanted to find out if a foreigner can bring an action under Article 2(1) of the Constitution. The word over there just says a person.
The foreigner can bring an action under Article 2(1) of the Constitution. Okay. Okay, let's take one more and then we will let our panelists will discuss this and then we take another set. So we take the 3rd one before we take another set of questions. So let's take George Anambintum.
Hello, Doc. Good evening.
Yes, good evening.
My question has to do with how to capture criminal authorities. Assuming maybe the authority says Odupon versus the state, and you forget and write Odupon versus Republic. Are they the same, or it should be how it is captured in our textbook, as in the title of the case?
All right.
Republic and the states.
Okay. All right.
Thank you.
Thank you, George. Okay, so we will deal with this and then after discussing them, we take another set of questions. Panelists, I think that there was a question as to how to write, if you have to write a memo, how do you go about it? Maybe let me start with this one and then I come to you. I have said before that when you are asked to write, to start with, drafting is not done at the law school. I call it back one. Drafting is not done at the law school, and for that matter, the focus of your exams is not so much about the drafting stylistics, drafting formats. You do conveyancing and drafting in the law school. So when you see write a memo, write this, those things should not take so much of your attention as to the substance of what the question is about. Okay. In any case, if the question says write a memo and you, for example, you don't know the format of a memo as a writing memo and then from to this subject, and then let's assume that you just went straight to the substance, and the substance definitely will have a good introduction, and then you develop the body, and the body, each main point is treated in one paragraph and all that, and have like a good paragraphing linkage, and then you have like a good general conclusion. You have done what the question essentially is examining. So assuming there's even a mark for the form, it will not be more than 2 marks. In any case, that is not what is really the point. So don't be so much fixated on write a memo, write a speech or write a brief or something like that. That is that is not what is really important. What is important is the substance. And don't forget that this is still an LLB. You are not in the law school, and the subjects which are taught, in any case, the same subjects which are being, yes, we do, Ghana legal system, you have a legal writing there, all right, but you don't do a lot of like advanced, drafting as you do it in the conveyancing and drafting and other things. So don't be so much worried about that. Having said that, I'll yield to my other panelists and take their view as well. Mr. Kojo, JBO, anything on that question?
Look, he's charging his phone here. He's on low battery.
Oh, right. Okay. So, Mr. Stanley Jamfi.
Okay, Doc. When it comes to the memo writing, as you rightly indicated, it's not so much about the form as about substance. It's about the substance. So the kind of question asked, if you are able to resolve it in the manner required, I don't think the form would, if you like, make you score a low mark or anything, because the only thing you have to, from subject date, those are the things that marks an item as a memo properly so-called. But so that I don't think that the omission of these 4 ingredients would, to a greater extent, affect the validity and credibility or the intelligence that you have poured out in your work. So it's not so much about the form as in the substance that you write in the memo. So don't be scared when you hear write a memo, write a this, write a that. Be very much concerned about how you are able to arrange your answer to make it very intelligible to whoever is reading. Because one thing about teachers and lecturers and all examiners is that they like to see that you have presented your work in a very nice manner, chronological order, such that it makes easy reading, so that your handwriting is even very critical. Sometimes somebody is making very, very serious point, but because of the handwriting, you have to strain your eyes in order to try to, because if you are to mark 100 scripts or 1,000 scripts, and you look at this, that you have to strain your eyes, it will take you about 45, 30, 1 hour, when you can spend less than 30 minutes on someone else's work. I don't think even you as a student, if you were examiner, you not take this lightly. So your handwriting, the order of presentation of your work, it should be chronological steps, such that you are able to demarcate your paragraphs. You are able to bring transitional markers, firstly, secondly, thirdly, furthermore, lastly, in conclusion. Those are the things that will make your work, that will set your work apart from the other person. So when it comes to write-ups, that is essentially what I would advise students to do. Because for me, I believe that when we start for the second one, the paper was cancelled. So the next one, it was a normal essay question, free for all. So you write a proper introduction, and in the introduction, you bring your thesis statement that in this essay, this is what you are going to do. So that by the time the examiner finishes reading the introduction, the person knows what you are going to do in the subsequent paragraphs. So if the examiner knows that, and sometimes they even read the introduction alone and they are satisfied. They feel that since you have written everything in the introduction, you're a good student, you can carry on with the rest. So they'll just mark you. And first impressions also count. So your introduction should be something that is very important to you. So spend your time, plan your introduction very well. And even if it comes to the IRAC, when you are starting with the areas of law issue, you start and plan it very well so that you write it in a way that is, everybody will see that, oh, this is the area of law. These are the issues that the person is raising. And this is the principles or the rules applicable to the principles. This is the discussion or the application of the rules to the facts before you. And this is your conclusion. This is your advice. At least you should compartmentalize them. When I say compartmentalize them, I'm not saying that write it in such a way you leave 5 lines and come and write this. No, but at least you have to make sure that the person reading will be able to decipher you leaving one topic and moving to the other topic, so that the person would, it helps. It helps. So even though you are writing for marks, so arranging it is very, very important. So don't rush to answer the question. Plan it. A very good plan. Do your draft of the plan that you want to. If you are able to do that, you are home and dry.
Right. Okay. Thank you, Mr. Jamfi. Yeah. So just to add one quick thing before I go to Mr. Ezekiel Seri and then Mr. Bio. Yes, much as we like you to have a good introduction, let me also share with you some things examiners or we teachers, we also don't like as far as the introduction is concerned. Stop beating about the bush in the introduction. Introduction is not just for you to write anything. The introduction should be purposeful. You let us clearly know exactly what you are doing in the, your understanding of the question, and then what you are going to discuss in the rest of the answer and all that. And don't bring a lot of unnecessary meandering or just beating about the bush. Sometimes a student can write about 2 pages introduction. It makes some examiners or some markers angry. So you need to be balanced and make sure that the introduction is effective introduction. So effective introduction is that which strikes at the question that as soon as you read a few lines, we are persuaded that you have understood the question, and then you have also signposted, what you've given some kind of a roadmap or signposted exactly what you are doing in the rest of the answer. So please, let's pay attention to that. Okay, thank you. So still on that same question, Mr. Ezekiel Osei, you have any additions? Mr. Ezekiel Osei, are you there? I think you seem to have lost him. Okay, so Mr. JBO, any additions? Since we seem not to be having them, we move on to the second question. The second question, Mr. Jamfi, the student would like to know if a foreigner can bring an action for interpretation or enforcement under Article 2 of the 1992 Constitution. The question is informed by the provision who says that a person who alleges, so the person here, the candidate would like to know, is it tied to nationality? Must you be a Ghanaian, or nationality is not important? Yes.
Okay, so Article 2:1 says a person who alleges that blah, 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 blah. So for me, a person is a person. Anybody can, a foreigner, I believe, is a person who can also invoke the original jurisdiction of the Supreme Court for enforcement of, because when we say enforcement of the Constitution, they are also persons who are living in the country, especially so if the person is not an illegal immigrant. If the person is not an illegal immigrant, the person must be a legal migrant who is here to do work properly, so-called, and not somebody engaged in any criminality. So when they say person under Article 2, a person can mean a juristic person or a human being, and a human being include foreigner and natives, citizens as well. And let's take a quick dash to Article 130, which also which is usually it dovetails into the Article 2, it says that subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to enforcement of the Constitution. And Doc, there is nothing here to suggest that a foreigner cannot invoke the original jurisdiction.
Mr. Jamfi, are you there?
Jurisdiction of the Supreme Court.
I think I lost the, I don't know whether from my end, I lost the ending. So I don't know if you can repeat the last sentence we just made.
What I said was that a person may be interpreted to include a foreigner, not just citizen, because there is nothing in Article 2 which makes reference to a citizen. It says a person. So a foreigner is also a person who can invoke the original jurisdiction of the Supreme Court.
Okay. Reference has been made to the case of the Psalm number 2, trying to suggest that the person there refers to a citizen of Ghana. Mr. James, what is your take on that?
That interpretation is not liberal.
Okay.
It's not liberal because to restrict it to only citizens is something that I disagree with. Because what about for corporations?
As a juristic person.
Yeah, juristic persons that have element of foreigners in it. When they invoke the jurisdiction of the Supreme Court, what happens to that? Will they be classified as citizens stricto sensu, as the company belonging to Ghanaians, or they'll look at the foreign element in it and say that no, you don't have standing because you're a foreign company? Because so a person here should have been interpreted broadly to include foreigners, so to speak.
Okay. But okay, so let's come back to the juristic person aspects. No, for juristic person also, like the companies and the rest, we know their nationality and conflict of laws. That is like the place of what? Incorporation. So for that matter, if the place of incorporation is Ghana, then the nationality of that juristic person, so to speak, is Ghana. So that is just for the addition, Mr. Jamfi.
Very well, sir.
Yeah, but rightly, as you have said, and those who are using the chat also are making interesting addition with respect to enforcement of human rights, especially, you know, if you go to chapter 5 of the Constitution and all. I think somebody is, please check your mic. If you are not, you know, speaking into the class, then you mute yourself so that you don't have like a feedback. Yeah. So the Psalm number 2 was not like absolutely categorical that under no circumstance can a person who is not a Ghanaian invoke the enforcement jurisdiction of the Supreme Court, as well as the interpretation as it is. So in that case, I agree with the TK that the interpretation of the person will have to be quite liberal or beneficial. In any case, don't let us forget that if you look at Article 1, if you look at Article 128, Clause 3, that the Supreme Court may, while treating its own previous decision as normally binding, depart from a previous decision when it appears to it right to do so, and no other court shall be bound to follow that. So when it comes to the interpretation which the Supreme Court has given and all that, yes, we have examples where there has been certain pronouncement, and then in other cases, when a good cause is demonstrated and the Supreme Court is persuaded that it has to, for example, make a departure as is permitted by Article 128, Clause 3, as I indicated, the court will do that. Yes, but where there has not been any departure, then the principle is that the most recent pronouncement or decision of the court will be the guiding precedent, the guiding position of the law, as it were. So, apart from Psalm number 2, if there is no any other known decision in which a contrary opinion has been given, that if you are a complete foreigner in terms of you not being a Ghanaian, as whether you are not like a natural person Ghanaian or a juristic person Ghanaian, you cannot bring an enforcement action under Article 2, then that is the position of the law. But as I said, the fact that Psalm number 2, for example, may be like the only position in which the court has given some interpretation of the person in Article 2 not applying to non-Ghanaians, does not mean that the door is closed, and that can never happen. It can happen, but as we have alluded to Article 128, if the court finds a reason which considers appropriate to make a departure from that pronouncement, then that will be done. So let us take note of that. Mr. Bill, are you here?
Kojo. Look, let me get my phone.
Oh, Mr. Ezekiel, sir, are you here? We have Mr. Ezekiel, sir, here. Before we move, yes. Chick, are you there? Then I've lost my panelists. Mr. B, are you back?
Doc, I'm here.
Okay, so is Mr. Bio there? Before we move on, I want to take their thoughts on this issue before we move on to the next question.
He has problems with his network, but he's trying to connect.
Oh, right. What about Mr. Ezekiel Osei?
Hello, please, I'm here. I think I was going on and off a bit, so I didn't
sorry.
really get the question.
So the question was in relation to the person alluded to in Article 2 of the Constitution as whether it is preferable to only a Ghanaian, and there has been contribution by the panelists that yes, based upon Psalm number 2, which we are not aware of any decision changing what the court said. that the person refers to a Ghanaian. And of course, in terms of like it's, having juristic person, that one is a different matter. You can go to the Lotto case and all that. And we are told that the person can also refer to a juristic person, but for the natural person, as whether the person must be a Ghanaian or it can be a non-Ghanaian. That was the focus of the person's question. So do you have any contribution on that?
Right, thank you, Doc. For what I know, when we look at the 31st December case,
yeah,
and then also the SIBA case as well, and even the Bimpombuta versus General Legal Council, which I think came subsequent to SAM number 2, it does appear that the position that the Supreme Court has taken in terms of the person as used in Article 2, Clause 1 is in relation to, number one, as you rightly said, juristic entities which have been registered under the laws of Ghana, and then 2, persons who are citizens of Ghana. That is what I get from those cases. Yes, from the 31st December, because when you look at 31st December, that is where actually that the debate, if I should say so, because that case was around 1993, that's where the debate actually started from, where the argument was made by the Attorney General that MPP doesn't qualify as a person under the law. So the Supreme Court had to interpret the word person as used under Article 2, Clause 1. And the interpretation that they gave was with respect to the fact that person as used is a citizen, a natural person who is a citizen of Ghana, and then a juristic person which has been registered under the laws of Ghana. And same definition was alluded to by the Supreme Court in the SIBA case, and then as far as I know, the Bimpombuta versus General Legal Council case. Yes.
Okay, all right, thank you. So maybe just to help the discussion, I would like to quote directly from the decision in SAM number 2, which reinforces the discussion being made. So I'm just quoting from part of the decision there. Quote, consequently, vis-a-vis the scope of provisions of Article 2.1 of the Constitution, 1992, there's no doubt whatsoever in my mind that it has a very wide span and imposes no such preconditions as have been contended by the defendant, nor do I see any need to read into those provisions any such limitation or preconditions. Indeed, to do so will be invidious and damaging to the very fabric of the Constitution. To do so would amount to an abdication of the duties conferred upon us under the article and will uproot the teeth implanted in the Constitution for its protection. Now then we come to the most important aspect. I'm still quoting the decision of the Supreme Court in SAM number 2. In my view, Article 2, Clause 1 is one of the most important provisions of the Constitution, 1992, since it deals with the enforcement. To limit its scope below the levels intended by the framers of the Constitution will be to emphasize on one of the most crucial built-in mechanisms for assuring the people of Ghana that their Constitution will always remain a living and vibrant instrument of social and political management and good governance. Every citizen of Ghana, by virtue of such citizenship, has an innate interest in the integrity of the supreme law of the land, the national constitution. As such, therefore, any perceptible inconsistency or contravention in any enactment or act or omission of any person for the constitution constitutes a sufficient occasion for the invocation of Article 2. The perceived existence of any unconstitutional enactment, act or omission is ipso facto a matter of public concern, and therefore any Ghanaian person, whether natural or artificial, so this is the crux of the matter, SAM number 2, and therefore any Ghanaian person, whether natural or artificial, has the standing, personal interest, and public duty to bring an action in this court to challenge its constitutionality. That is the regime created by Article 2, Clause 1 to assure the full effectiveness of Article 1, Clause 2. In the context of Article 2, Clause 1, therefore, there can never be any official bystander or a nosy busybody. Every Ghanaian is and must be an interested party. This, I believe, has always been the position of the court since the Constitution in 1992 came into existence, unquote. Yeah, so it will go on and make reference to the case of Bilson versus the Attorney General, and then just try to demonstrate further that the person referred to in Article 2, Clause 1 is referable to a Ghanaian, whether it's a natural person or a non-natural person, as in a juristic person. So I think that based upon these inputs from panelists, we've discussed this issue enough, and we can move on to the next question, the third question. The third question was that and the person who had the question was that how to capture criminal law authorities. If you have something like Odupon against the state or Odupon against the republic. Okay. Well, the question, if what you said is what we understood, this is what we will say, that before we had the 1992 Constitution, if you look at some of the old cases, especially during the military era and all that, you see the case of State versus Ochre, State versus Kwache, and so on. In those times, criminal law cases, we often, the state will be referred to as like the state. But now if you look at Article 88 of the Constitution, no criminal cases, right? Since 7 January 1993, the state is presented as the republic. So it will be Republic versus Odupon from your example. But if there was an appeal, maybe you were convicted in the court below, you decided to appeal it, then the republic will become like the respondent, and you, the accused who is now convicted, now will become like the appellant. So it can change as maybe Odupon against the republic. But coming back to the question that what about if you've forgotten like the full title? I think that one is not unique to only criminal law cases, even to all manner of authorities, tort, contract, or whatever. You can forget the full title. So what do? So let's suppose that you've read the case of Odupon versus the Republic, but let's say that you've forgotten to add the Republic and you only remember Odupon. You can say that in the criminal case of Odupon, where the court held or the court decided, if as a matter of truth, you know that case and you put it that way, I think that your examiner will give you the appropriate portion of the marks because you have evidence that you know that case, except that you've forgotten like the full title. So that shouldn't be so much of a problem. So the most important thing is, do you really know that case? If you know, but due to pressure of examination, you've forgotten the full title, you can say that in a case, in a decided case, the Supreme Court, that if you are sure there's a Supreme Court decision or the Court of Appeal or whatever, then you tell us what happened there. It will be acknowledged. If the mark is, let's say, if there's, assuming it's 3 marks for that, if you don't get the full 3 marks, you could get probably 1.5. Or if you are lucky, you can get 2/3 out of that. So that is not bad. Panelists, I don't know if you want to have some additions to this particular question. Yes, Mr. Stanley Jamfi.
Look, I associate myself entirely with the submissions that you have made in respect of this particular point. And except to add that, you can also say in the Odupon case.
Okay.
I'm sure, yeah, that one too, provided the holding that you have is the same as the holding in the Odupon case.
Okay.
That will also be a good starting point. But as much as possible, you have to try, but there are times that you can't remember. So the Odupon case or in the criminal case of Odupon is still acceptable.
Okay. All right. Thank you, Mr. Jamfi. Mr. Ezekiel, sir, anything to that? Okay, I think he's not there. So is Mr. Biwa around? Yeah, okay.
Not yet, sir. Not
All
yet.
right. Okay, then you take another set of questions. I think we've exhausted this. So we're going to take 3 more questions and then we deal with them before we take another one. So if you want to ask a question, raise up your hand and then I'll call you. Mabel Sasa.
Hi.
Yes. Yeah, go ahead and let's.
Please, can I go ahead?
Yes.
Okay, so I have a couple of questions, but then I'll take them one after the other if time permits. So my first question is that I would like to know the position on political question in Ghana. Is it that it applies in Ghana, but then it is restricted by the doctrine of constitutionalism, or that it does not apply because of the doctrine of constitutionalism? And then with respect to discharge by frustration, I would like to know if sickness operates to frustrate a contract, given the holding in Davis Construction versus Faham.
Take that again, please.
My second question has to do with discharge by frustration.
Okay.
I would like to know if sickness operates to frustrate a contract, given the decision in Davis Construction versus Faham.
Okay.
And then the third question has to do with the doctrine of stare decisis. We've had multiple of cases basically saying the same principles. For instance, into 4 versus Attorney General, and then some recent cases.
Mabel, we are not hearing you well on that.
Okay, so I'm taking the third question again.
Okay.
So I'm saying that with respect to the doctrine of stare decisis. So for instance, we've had similar decisions in Tofo versus Attorney General, J.H. Mensah versus Attorney General, and then recent decisions like the Ezwaming Annan versus the Attorney General and then Speaker of Parliament. I'm asking that in the event that you are citing a case to kind of argue similar principles, is it that I go with the earlier decisions, or it's okay to cite recent decisions?
Okay. All right, thank you. So Mabel alone has given us the Trinity, trilogy of questions, 3 questions. Nevertheless, we'll still take 2 more students so that we can let the panel deal with them. So John, you are next.
Good evening, Doc.
Yeah, good evening.
Respectfully, I have a question that is a bit unconventional, but I pray and hope that this doesn't happen to any of the candidates.
Okay.
But respectfully, when you get to, what if you get to the classroom and then you see the topic and you seem not to have mastered very well the topic, yet you have an idea of the topic? Is there any way the panelists can instruct candidate on how to go about it such that the candidate doesn't lose all the points on that session, yet to be able to get few points that will make the person sail through? I don't know if the question is
yeah, thank you. And I
well
think
understood.
that you have actually spoken the mind of many students who probably have this question hidden somewhere in their mind or hearts, but they lack the courage to ask it. So it's a very legitimate question. John, we will discuss it. Thank you. Let's take the third student and then we come back to the panelists to dispose of them before we take another set of questions. Yes, so Paul, yes.
Yeah, Doc, good evening. Please, can you throw more on plea bargaining as you said under criminal law?
Plea bargaining, okay. Okay.
Thank you.
All right. Good. Okay, so we come to panelists. We discuss this before we take the next step. So the next step we start with like Asante data. When we are ready, I'll call you. Mabel, as Mr. Jamfi, Mr. Bill, Mr. Ezekiel, I hope you are with me. So we had a question from one student, Mabel, that she would like to know whether the doctrine of a political question in constitutional litigation, does it apply in Ghana? Or because of constitutionalism, it does not apply. Okay. Or like, yeah, so because of constitutionalism, it does not apply to, or does it apply? That is her question. Well, I will let my panelists come in, but just before they come in, let me set a certain context that political question doctrine is a doctrine which developed against a certain backdrop. You all know the case of Marbury and Madison in the United States, in which the US Supreme Court, through the creativity of Chief Justice Marshall, used a very creative reading of the US Constitution to assert the power of judicial review so that the Supreme Court will pronounce on constitutionality of actions or inactions of other organs of government, because as we know, is not explicitly enshrined in the US Constitution. So that was done successfully. But as you know, there was the rare fear that there was the fear that there could be a backlash. So the Supreme Court had to develop a clever means of trying to discipline how it uses the power that it has actually asserted, which was not explicitly enshrined in the Constitution. And that is why they adopted this doctrine, what we call the political doctrine question, that matters which appear, if you like, properly within the the executive domain, and does not really have, if you like, a direct implication for the constitutional architecture, allocation of powers, and so on, then the court will try to stay away from that. And this was done, as I said, a very cautious move in order to avoid the other organs of government, especially the executive and probably the Congress, to say that you judiciary, the Supreme Court, you arrogated to you the power to be presiding over whether we have acted in accordance with the US Constitution or not acted. So that is a backdrop. And for that matter, what we have in Article 2 of our Constitution, and also Article 130 and all that, you don't have analogous, if you like, a provision in their Constitution. So that is the first thing I would like to remind us. So that is the first thing. Of course, you look at the cases like Tufo versus Attorney General, and then J.H. Mensah case, and even the 31st December cases and all that. Some allusions are made to that, but you see how the court actually addresses them. Okay, so having made these generalized remarks, I will yield to my panelists to give their thoughts on that question, and then I'll come back again. Okay, Mr. Jamfi, Mr. Bill, Mr. Ezekiel, sir, if you are there.
My thoughts on the political question, political doctrine, question doctrine is encapsulated in the words of Akins, JSC, in the case of J.H. Mensah versus Attorney General.
Okay.
And according to Bimpombuta, this particular case sums up the true legal position on the application to Ghana constitutional law of the political question doctrine. So he says that this is what Akins JSC, as it then was said. He says that admittedly, the principle of a non-justiciable political question is an American formulation that is steadily creeping into the Ghanaian jurisprudence. In the American case of Baker versus Carr, the court discussed the political question doctrine and noted that political questions are not justiciable, primarily because of the question of separation of powers. It pointed out that in deciding generally whether a claim is justiciable, a court must determine whether the duty asserted can be judicially identified and is breached judicially determined, and whether protection for the right can be judicially molded. But in Powell versus McConnell, the court said, in order to determine whether there is a textual commitment to a coordinate department of government, the Constitution must be interpreted to determine first what power the Constitution confers upon the House through Article 1, Clause 5, before the court can determine to what extent, if any, the exercise of that power is subject to judicial review. So, Doc, in essence, I would say that the political question doctrine is applicable, but there is a thin line between what is committed to an institution of government, because if recent happenings is anything to go by, when the deputy speaker voted in the House, the court did not consider that to be a matter strictly committed to Parliament. The court made a determination on it, though it was a political question, a doctrine, but the court made a pronouncement on it. Because if you look at what happened, it was matters strictly about Parliament, and there is a principle that they usually say that what happens in Parliament stays in Parliament, and Parliament is the master of its own rules. However, the Supreme Court assumed jurisdiction in that matter and made pronouncement on it. So there is a thin line between the political question doctrine,
okay,
as applicable in Ghana.
Okay, all right.
And JSC, SOA JSC in to 4 verses in the to 4 case stated that the courts cannot therefore inquire into the legality or illegality of what happened in Parliament, insofar as Parliament has acted by virtue of the powers conferred upon it by provisions of Article 911. Its actions within Parliament are a closed book. The above were the considerations that led to our conclusion that the Speaker ought not to be a party to the present proceedings and be accordingly discharged him as the first defendant.
Okay. All right. Thank you, Mr. Jamfi. Yeah, so before I say a few more words, Mr. Ezekiel say, Mr.
Right.
Yeah, Ezekiel, yes, Ezekiel.
Yes, so I want to give a bit of clarification on what Lawyer Stanley said. So actually, when you look at the political question doctrine, so far as I'm concerned and the cases that I've read, there have been about 3 cases, earlier cases, that the Supreme Court has sought to discuss that particular doctrine. The first case that the Supreme Court was confronted with that political question doctrine was the MPP versus AGK, that is 1st December case.
Yeah.
There was an argument that was raised by the Attorney General to the effect that the Supreme Court does not have jurisdiction to question the decision of Parliament to pass an enactment that will lead to the disbursement of funds for the celebration of the 31st December as a coup day. Now, the majority, it was actually a 5-4 decision. The majority of the court were of the opinion that when you look at Article 2, Clause 1, it doesn't differentiate between legal questions and political questions. And for that reason, all matters, once it has a constitutional implication, could be brought under Article 2, Clause 1. And for that reason, the doctrine wouldn't apply. Then fast forward, we came to have the GBA case, that is the Ghana Bar Association versus the Attorney General case, whereby the Ghana Bar Association sought to challenge the appointment of Justice I.K. Aban as the Chief Justice of the Republic of Ghana on the basis that Justice I.K. Aban is not a
Ezekiel, are you there?
court. Please, can you hear me?
Yeah, I think your line went off, at least from my end, briefly. So, starting from the
okay.
IK,
so I was saying that
case, yeah. The GPA versus the
I was making the point that after the 31st December case, the
I think we seem to have lost Ezekiel. Okay, so
dog.
Yes. Yes.
Hello, dog.
Yes, we can hear you.
Can you hear me?
Yeah, we can. Yes, Ezekiel, we can hear you. Go ahead. We can hear you. Go ahead.
Hello, can you hear me?
Yes, please. Yes, we can hear you. Go ahead.
Right. So I was making the point that after the 31st December. Okay.
I don't know whether I'm the one not hearing him or he's off. Mr. Jamvi, can you hear Ezekiel? Because I cannot hear him.
No, I can't hear him. It appears he's talking about his mic moves, the green moves, but
right.
I think his network is terrible.
Okay.
Hello, Doc.
Yes, I think we
Hello, Doc.
Yes. Yeah, we can hear you now. Yes.
Hello.
Yes, Ezekiel, we can hear you now. Go ahead.
I don't know why they come.
No,
hello.
We can hear you. We can hear you. Go ahead. I don't know whether we are having Mr. Jamfi, is Ezekiel still here?
Okay, left.
Oh, right. Okay.
Yeah, I think he wants to rejoin.
Oh, okay. Let me see. Yeah, you see, if you look at the case law since the 1992 Constitution came into force, you notice that we have a line of cases in which sometimes by a thin majority, maybe 4 to 5 and so on, they've suggested that political questioning doctrine is applicable, and some judges want to suggest that it's not applicable. And if you start from the 31st December case, you see Justice Adade. You come to the Amidu versus Kufuor. You look at the position that the PEGA took and how PEGA will even go ahead to try and give us indicators of what he considers as bringing about the question of what we call like the political question, as among other things, that if the court is to pronounce upon something, will the court, for example, be usurping, if you like, political power, which has properly been conferred on maybe like the executive or the legislature through the framers and also through the electorate. And the recent Justice Abdullah against Attorney General also brings another layer as to whether the courts can actually delve into the internal workings of even like the parliament, as whether they've met their quorum, they haven't met their quorum, as to whether they could carry out their transactions in a particular way. Just similar to what we saw in the case of J.H. Mensah and also Kufuor versus Attorney General. There is a very interesting a research paper which someone has done on trying to examine all the cases in which the question of political doctrine has come up. Those cases in which the court uphold, for example, legislative decision to declare public holiday like the 31st December, for example, as a political question. And then those instances where the court upheld appointment of like a chief justice, as the Urban case, which was alluded to as a political question. And then where the dismissal of the appointment of cabinet minister, for example, like the J.H. Mensah versus Attorney General, was also upheld as a political. The person has beautifully assembled all the instances. The only one which is not included is like the recent case of the Justice Abdullah versus Attorney General. So those of you who are on the platforms, I will just put it there for you. And then it's not a very technical work, it's a student work. So it's something that you can easily understand at your level. So the question as whether political question doctrine applies in Ghana is yes and no. No, because if you look at some of the judicial dicta in some other authorities, they will take the view that if you look at the background to that doctrine, then based upon our constitution, as they said, the whole of the constitution is a political document, as it were, as well as even like the directive principles of the state policy, which was a very big example of where we encounter with what they call the non-justiciability, because the matters over there definitely even involves political choices, resource allocation, and so on. And you wonder, can the court actually determine whether the government, for example, has failed in a particular way by not making enough resource allocation? And if you go to India, you notice that there are decisions where the court will even go to the extent of examine the budgetary allocation by the states in order to establish whether the government is living up to certain constitutional obligation reflected in what we call like the directive principles of state policy. And yeah, so that is the views we express for the time being. Mr. Bill. Okay, then there's a discharge by frustration. That's sickness operates to frustrate contract, given Davis contractors and Ferreham. Yeah, so a sickness grant for frustration, I think that is the question that the person asks. That if you have obligation to perform under the contract, can you say that because you fell sick, you're unable to perform and you are discharged from the obligation? I think there are, I noticed that some of you have written in the chat, citing some of the coronation cases, that sickness is a ground for frustration. I think we need to put that in context. First, we have to understand frustration, as the person rightly alluded to Davis contractors, Lord Radcliffe definition, where you have a supervening event which renders performance of the contract practically what impossible, so that if you are to insist on performance, you'll be holding the parties to the contract to something radically different from what they actually contracted to do. So once we have that understanding, then we must appreciate that if the obligation involved in the contract, for example, is personal service, okay? If it's personal service, that would say that someone is supposed to do something in person. Then since the obligation is a personal service, if there is a sickness, if you are sick and medically certified and you cannot perform that service, definitely that can serve as a frustrating ground. But it's not all types of contract. As I said, it is only personal service where sickness will operate as frustration. Those who cited the coronation cases, the focus there was not personal service. The focus was what we call it the purpose of the contract. So just like you've rented a place so that you can have a good view of the coronation procession, or maybe there's going to be a royal review of ships or fleets of ships, and it is cancelled because the king or the queen is sick. Here is not the sickness, which is a frustrating ground, is rather the purpose of what? Of the contract. Because the purpose of the contract cannot be achieved. It cannot be achieved because the person who's supposed to do the review is sick. But as I said, you didn't have like a personal contract with the king. So that is not the frustrating ground. But there are some instances, maybe a musician, you've hired a musician to come and perform at an event, and then he or she falls sick before the event. So that one, the sickness in that case is a good illustration of frustration and so on. Mr. Jamfi, I don't know if you add some few thoughts to this particular question before we move on. Mr. Jamfi, are you there? Mr. Bio?
Doc, I'm here. I went
Yes.
offline.
Okay. Yes, I think we're explaining whether sickness can be a ground of frustration. And we said, yes, if it's involved like a personal service. But apart from personal service, you cannot cite that as a frustrating ground. And I wanted to find out if you want to make some additional inputs.
Yes, when it comes to whether or not sickness can be used as a ground for frustration, yes, it can, especially so as Doc rightly indicated, in personal services, so that the occurrence of the event, such as probably death of a person, serious illness, or probably accident, or the person being called out for war, or the person may be detained, may result in frustration if the contract for which he's engaged in is for personal service. But absent personal service, then sickness would not constitute or amount to frustration if the contract that has been entered into or executed between the parties is not for personal service, but is for any other thing aside personal service, then it will not be a ground for frustration.
Okay. All
So
right.
let's assume that there is a contract for personal service and the person is arrested and detained. It may be a ground for frustration. So the court may interpret that to be for frustration. But let's assume that the contract is not for personal service and somebody probably even not remotely close to the contract has been detained. That if it's not for personal service, for which reason the availability of the person is necessary for the performance of the contract. If that is not the case, then it will not be classified as a frustration.
Okay, all right, thank you. Then there's another question. Is Mr. Zigose back? Is Mr. Bio back?
Yes, dog, I'm back.
Oh, okay. Okay. We've moved on to the question on the persuasion, but you're making your closing remarks on the political question doctrine, and then your line went off. So maybe if in a minute, if you can summarize ideas before we move on to, you come back to have a few words on the frustration question, then you move on to the next question.
Right. Thank you very much, Doc. Pardon me for my network. Yeah, so I was making the point that there have been 3 cases of the Supreme Court where this question has come up for discussion. So I mentioned the first case, which was MPP versus Attorney General, which is the 31st December case. Over there, the Attorney General raised a preliminary objection to the jurisdiction of the Supreme Court on the basis of political question. And why was the Attorney General saying that the question was a political question? Because of the fact that he believed that the mandate or the power of Parliament to pass a legislation was under
I don't know if, are you there? I think the network is not helping. Pardon us. Yeah, pardon us, the network is not working as we like it to. Okay, so let's move on to, then we have to dispose the other issues. Okay, so there's a question about stare decisis, and the person wanted to find out if you have the same, the same principle, and it's been articulated in different cases. If you have to cite the case, must you cite all, or must you cite only the recent one? Well, maybe one thing we should remember is that we, in our country, you can take sometimes about 10 cases, and the 10 cases are saying the same thing as far as particular principle is concerned, right? So therefore, where they are all saying the same thing, if you cite one case, that should suffice, except where there has been maybe a refinement of the principle. And the question is an essay question, so that you are supposed to discuss how a particular principle has evolved, right? Has evolved through the case law, in which case you need to trace, the very first maybe authority in which that principle was somehow articulated, and then subsequent refinement or modification up to the most recent understanding of that principle that we have. But in absence of that, if there has been no significant, I just give you a typical example. When it comes to spousal property right, for example, That is the one area where you get a good example of this. Starting from the Mensa and Mensa, Fin and Fin, and those line of cases, where in one breath, the Supreme Court will tell us that once you have a property acquired during the subsistence of the marriage, then during the subsistence of the marriage, then there's a presumption that is a joint matrimonial property, and then one case will say that there's a presumption of equality. Then it's supposed to be shared equally between the parties. Then another authority will come later on to come and say that no, it doesn't mean that it's supposed to be shared really 50-50. That the court will have to actually look at the circumstances of the particular case. So that is, for example, one typical example where you may need to canvass all the available authorities to show how that particular principle or that particular concept has actually developed. Otherwise, where the same principle has been applied, sometimes the cases are just applying the same principle. If it's just applying the same principle, it's not laying down any new precedent. It's not, so let's get the distinction. It is one thing where the court is actually either making a departure from the known position of the law, in which case is actually laid down, if you like, a new precedent, or other cases is just applying the known state of the law to another set of facts. In that case, no new principle is articulated. So let us keep that in mind. So that is the what we can see by the stare decisis. Yes, Mr. Jamfi, do you have additional points to make? Mr. Jamfi, are you there? I think. Mr. Jamfi, are you there?
No, please, I'm here.
Yeah, so the question on the stare decisis, do you have any more to say before you move on?
Yes, sir.
Okay.
All that I would like to say is that for every principle, usually there are locus classicus, which is not lost on any lawyer or examiner. So for those ones, you can cite the locus classicus. For instance, if you take a promissory estoppel, you know that the high trees case is the locus classicus on that. You can cite that. And if probably you want to be very forward-looking, and there is a recent case which also states the same principle. So you can say, as was recently re-echoed in the case of, if it's a recent case, then you cite that case as well. But if there's been a refinement, that is where Doc's admonition becomes relevant. If there's been a refinement in the principle, then it means that you have to trace it from all the cases, the latter ones, the more recent ones that introduce the refinements, then you have to state all those ones. But if the recent cases essentially re-echoes the previous locus classicus, then there is no point citing so many authorities. You can cite the locus classicus, one or two of the recent ones to add to show that yes, you are to make your work very scholarly, because we are all looking for marks anyway. So how to make your work different from someone else's work, then you can cite some of the recent ones to which re-echoes the previous decision.
Right. Thank you, Mr. Jamfi. Just to pick a sentence from what you said and re-emphasize that. And I told some students yesterday or another occasion that don't let us forget that the law school entrance examination is different from the school examination in one particular respect. The school examination, we're interested in really testing your knowledge as whether you have attained what we call the intended learning outcomes of the various subjects that you did, basis of which you are going to award a grade to you and then give you a degree to certify to the whole society that we as an institution can testify that Mr. A or Miss B has attained this learning outcome. So that is the purpose of the school examination. The law school entrance examination is different. The purpose is different. We will not make any mistake about that, and no pretensions about that. That examination is just what we call like a sieving examination. We cannot take all of you. So who should be taken and who should be left out? And that means something. And I just want to tie that in with what Mr. Jemfi said, that because it's about selection, don't miss the opportunity, if the opportunity presents itself, for you to make the most impression, because you want to answer to stand out, right? You want your answer to stand out in a way which will make the most impression, so that you get as many marks as are meant to be allotted. And that way you secure your seat in the next first year class of the law school. So that is the purpose. So as I said, it's different from normal school examination, where you want to measure your attainment, the knowledge that you've attained. Because quite frankly, the fact that the various universities are giving you the degree means that they have gone through their rigorous system to determine that you merit either the second class lower, or the second class upper, or the third class, or the first class. But the law school entrance examination, as I said, it's just a selection exams. So just to take by their standards, those who are very good from the rest. And then those who are very good are those who make more marks from that particular question. And that is why if you have the intellectual resources and the skills to let your answer stand out along the lines that we are explaining, make use of it. That is all. So if you have the authorities and they are on point, make use of them. Your answer will stand out. But what you should avoid is to be citing irrelevant authorities, or authorities which are not really on point. That one, you'll be punished severely, because you are trying to deceive your examiners, okay? Because if you get the marking scheme, what will happen is that all major known authorities will be listed. So if we get to know that, let's say that if about 7 authorities are listed and a particular answer, and you have cited 10, 15 authorities, and none of them is, not even one is from the 7 listed, then we begin to wonder, you alone, where did you learn or take your law from, isn't it? Because if you cannot get all the 7, at least 1 or 2 should fall within the 7. So that is what you should keep in mind. So moving on, John asked the question. I think that I like John's question, and let's pay attention to that well. John's question was that, and of course, he prefaced it by saying that his question is unconventional question, okay? John's so-called unconventional question was that you get to the exams, you see the question, you have idea, but you don't have mastery about what the question is asking. How do you go about it? Okay, so John is inviting us to give what we call the desperate response in desperate situation, because you go to the exams hall, you are there to pass. You are not there just to go there and then say the next time I'll come and write again. No, you go there to pass. So there's nothing like this question, I cannot do it. You must do it. So how do you do it? I mean, that is his question. Good. So if you have gone through the kind of revision that you have suggested, and maybe in case you are hearing us for the first time, earlier on, we suggested that the best way to get ready is to do self-audit. The self-audit simply means that the 6 subjects, Ghana legal system, law of contract, constitutional law, criminal law, land law, law of torts, you sit down on your own, just put all your books aside. You can get the one exercise book and say that, okay, I'm going to start constitutional law on my own. Let me list all the topics which are meant to be taught and known in constitutional law, right? You do that on your own. Then when you finish, take each of the topics that you have listed and quickly try and summarize the main ideas on your own without opening books, without going online. The main ideas that on your own, you can summarize under that topic. And then the authorities, the key authorities, remember under that topic. Just list them. Then move on to another topic. You do that for all the topics under constitutional law that you have done. When you are done, you can quickly do your own marking. Go take the textbooks or the notes and then find out where you fall short. You flag it, and then you do where you are seriously deficient. You go and do a bit more work there. So that is about that. Then you move on to another subject. Law of torts. You do the same thing as I have suggested. You repeat that for criminal law, land law, contracts. So once you've done this, what it means is that you have sincerely and honestly revised all the topics in all the subjects. So coming back to John's question, you go to the exams and you notice that there is a question on independence of the judiciary. You don't remember, in details all the things that you've learned, but how are you going to answer that? Okay, so our advice is that the little that you remember or the little that you understand as far as that question is concerned, use clear and effective English language and also logical arrangement of your ideas to present it. So pay attention to that. So if, like, the particular question, you have just a rough idea, you don't have a lot of information, the little that you have, organize ideas well and use a good, effective English language to present your answer in a very neat way. Even if you're not going to get all the marks, you get something. It's better than you just leaving the paper blank, or you just writing anything without giving thought to it. Because if you don't give thought to it in terms of the structure, how the answer appears, if your script is fake, the person will just run a line around it and probably give you 0 or just give you 1. Being given 0 in this type of examination, in all sincerity, I can tell you is the easiest thing, because there are a lot of scripts which your examiners are dealing with. So don't make it easier for your script to be graded 0, okay? And you can easily avoid that. Mr. Jamfi, if you give some clues as to how to get a desperate response to desperate situation, you get to exams room, you see the questions, you don't have like graphs, you don't remember a lot of the details which you ought to have known. Just some rough idea. How do you go about it? And the person to want to fail, the person want to pass.
All right, Doc. I'll make a personal confession in this regard. I remember in part 2, my evidence, I had learned deeply into the course, but when we went, they brought the basics. And by the time I finished reading the questions, there was no one that I could answer satisfactorily. So I started to panic. My legs were shaking, and I said, so at this point, I'm coming to fail evidence. So I said, okay, let me go back. So I read through again. Still, I couldn't. I read through again. I said, since there is no other way, I still have to do something. So I picked amongst the 5 questions, the 3 that I could answer. But one thing is, the mind is a very special mechanism. The mind, God created it in a way that is a special mechanism. So when you get to that point, that is where planning comes in, as Doc rightly indicated. If you are able to plan your work well, write very good English, you will get your pass mark. That I can assure you that you may get it, even though your work will not be replete with the legal requirements, the authorities, so to speak, that are required for that particular paper. But if you are able to pick one or two, state some principles, and the principles, if it's a principle, definitely you might know the principle, but you have forgotten about the case. So when you indicate the principle right, they will give you something. Definitely you get something. So that is where you have to plan and really bring out the best in your work, even though in terms of substance, you know that, oh, there is no, the substance is not much, but the way in which the work is arranged, the way you write legibly, the way you construct, you string your words together, it might invoke some sympathy in the examiner, and you might get something, because the examiners are all human beings. So when they see how you have presented your work, definitely it may invoke some sympathy in them.
Okay, Mr. Jamfit, thank you. I mean, anytime we speak, it provokes something additional in my mind. So let me just bring this thing out. Please, when you are writing your answers, we have two things. Writing authorities is different from explaining the concept or the principle. You are supposed to explain the concept or the principles first before you cite authority. If you just put the authority there, bang, and you don't really explain the concept or the principle, you haven't done what is required of you. So, as part of dealing with John's question, you may have a very good understanding of the concept, but you don't remember the authorities. That is fine. Demonstrate your clear understanding in the way that you render yourself. Even if you are lacking in authorities, and then the explanation is quite clear, is quite succinct, and it gives evidence that you definitely understand the principle, you understand the concept, you understand the topic, you will get reasonable marks. Yeah, so that is why I'm saying that make sure that you have a proper grasp of the principles, of the concepts. That is the first thing. And then knowing the authorities is the second thing. If you just know authority, but you don't understand the principle properly, it will also show in how you write your answers. So both are important. So get the understanding of the principles. If you get the understanding of the principles, should the worst happen that you've forgotten the authority, you'll be able to fall upon the explanation because you understand the principle or the concept. Okay, let's take.
Okay, Doc,
yes.
Doc, let me add one. When it comes to general knowledge questions too, sometimes, yes, I remember in our time, the entrance exam, the second one, the number 2, which we went, the recit that we went to do, there was a general question on corruption and another one on the jury system. Now, when you look at the jury system, there are some statutory provisions that you can quote. But for me, I didn't know so much about the jury system and how it works and all that. So I decided that no, I wouldn't tackle it. So I did corruption. And corruption, I didn't have any statutory provision because I didn't anticipate it anyway. But when you go to the Criminal Act, there are some provisions in relation to corruption, but I didn't quote anything. But the way and manner in which I arranged my work, I'm sure, is one of the reasons why I passed, because I didn't have any statute backing it, because I felt that it was a general question. So if it's a general question, then I have to answer it in the manner I saw fit, especially so when I didn't know readily, I didn't know any statutory provision. But that does not mean that if you know the statutory provision, don't use it. You have to use it. But a typical case in John's matter is when you arrange your work beautifully and, so that the examiner would have sympathy on you. So you have to do your best in that regard. So when it comes to that, in that matter, you have to do extra work, even though you don't have a full grasp It means that in planning your work, you have to do extra work in order to catch the eye of the examiner. So that is what I'll add to it.
Okay, thank you. I think thank you, Mr. Jamfi. Is Mr. Bio and Mr. Zikosa, are you back?
Mr. Bio.
Okay. Mr. Zikosa, you don't have them. Okay, that's fine. Is Lawyer Gertrude here? Okay, she's not here yet. Dr. Innocent, are you here? Okay, I think they are not here yet. Okay. Paul asked a question about plea bargaining. Mr. Jamfi, I think that we will stick to what we said, that we've had the whole discussion on the plea bargaining not long ago. We made even like the Ajua Samoa do a whole presentation, and we have like the session recorded online. And then you go to Ghana Law TV on YouTube, and then you type plea bargaining, Afia Samoa or something like that. The recording is there. You can play it and listen. Then we also sent the slides on the platform. So I'm sure that somehow it's gotten to wherever you are. Otherwise, Mr. Jamfi, if you say a few words about plea bargaining for the sake of Paul.
I'll hand over to Ajua.
Ajua is around.
Yes, please.
Oh,
Since
Ajua
she's
then, yes,
expert
Ajua then
plea
take
bargaining.
over. Okay.
Hello.
Yes, Ajua is around. And David too must be around.
No, Doc.
All
it's
right.
Ajua,
okay.
Belinda and Loretta who are around.
Okay.
So with the plea bargaining, simply it involves a number of things, 3 things. So in Ghana, when there's plea bargain, it's either to reduce the offense that has been charged to a lesser offense, or to withdraw a charge against an accused person, or is to reduce the punishment for an offense charged. And with the plea bargain, either the prosecution, the accused person, if he is acting, he's proceeding pro se, or if he's represented by counsel, then the counsel, any of them can initiate. And it's strictly between the accused person or his counsel on one side and the prosecution. The court is not involved when it comes to the bargaining itself. However, afterwards, the court can either accept the agreement that they enter into or reject it. And the parties are free to also withdraw at any time before judgment is entered. Also, the agreement, if the court accepts it and enters it as judgment, you cannot appeal against it. You can only apply for it to be set aside. It's not a judgment that can be appealed against. Yes, and then there are some offenses that have been exempted. So we have treason or high treason, high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and an offense related to public elections. Yes, Doc. So that's what I can say about plea bargaining in Ghana.
Okay, all right, thank you very much. So as I said, if you want like the detailed discussion, which has been done, you can play. It's just about, I think, 40 minutes or 1 hour video recording. You can listen to it. Good. So we take the next set of questions. I think we'll be doing this for quite some time. So maybe it's now 8. Probably maximum in the next 15 minutes, we should be closing. Tomorrow, as I told you, we have another panel discussion with Dr. Abdul Bambam Bassett on criminal law and also constitutional law. That will be at the 5 p.m. or 5:30 p.m. The link has been sent to your platforms. So we take the next question. So Ivy Asante and then Naomi Edufo. These are the 2 on hand. Yes, Ivy.
Hello, good evening, Doc.
Yes.
Okay, so my question, I have two questions to ask. The first one is, if the president makes a declaration outside the country, is it binding on us here? Is it binding on the citizens in Ghana? And the second one is, how do you tackle a question on the same-sex marriage? If it comes up, how do you tackle a question on that? And if there are provisions
No, can you take that
for
again?
that?
The second one. How do you settle a question on?
No, how do you tackle when you have a question on same-sex marriage? How do you tackle it?
Oh,
And if there are
okay.
provisions in the constitution governing that as well.
Oh, okay. Okay,
Thank you.
so all right, thank you, Ivy. Naomi, let's take
Yeah,
it.
so thank you very much. This is a simple one that I wanted to find out. So you have a question that says, advise the parties. That one, you know exactly what you've been called to do. But in the event where the question is asking you to address just the legal issues, then do you go a step further to give your advice as in the courses of action to take and the remedies that are available, or you just end at your conclusions with no advice since the question didn't ask you?
Okay.
Thank you.
All right, thank you, Naomi. Sachibia.
Hello, sir. Good evening.
Yes, good evening.
Good evening, sir. I have a question, and it has to do with, hopefully, I think it's connected to what the lady just asked. What if the question, I have a question in front of me. Let me go straight to the point. And it's on breach of a contract. Instead of the normal advise the parties or give a legal opinion on the facts, the examiner goes on to ask you, for example, state the course of action, state the remedies, blah, 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 like give you like 4 pointers that you need to address. My question
So
is,
state the remedy.
how do you go,
and what again?
like the course of action?
Yeah.
And it's more like a comprehension question. You are
Okay.
given certain facts
And then maybe
some
defenses or something like that.
Exactly. My question is, how do you go about such a question? Is it an essay question? Is it a problem solving, you use
Question.
hierarchy or something? I
All
don't
right.
know, because I'm really stuck. There is a question for 2015 on breach of contract. I think question 2, yes, where a guy promised to marry a lady and ended up not marrying the lady and getting another person pregnant and all that. And instead of the normal advice the parties, the examiner was like, what is the course of action and all that. So my question is to find out how, as a student, what is the expectation of you when it comes to questions of such nature? Thank you very much, sir.
All right, thank you. Okay, so we start from the bottom. So we start from Sachibia. If you have a scenario or problem-based question, and instead of the usual thing that advise the parties or write legal opinion, you have what you call the pointer. You call them pointers, where you have like a pointers. State the course of action, state the remedy, what defenses, and so on. Now, if you have that type of question, you are excused from going by, let's say that the strict approach of the hierarchy. So here, you are being directed. So since you are being directed, you take, state the course of action. Maybe a good student will explain that a course of action is understood as a factual scenario for which the law will give a remedy. So in this particular instance, we need to identify whether the scenario provided is one for which the someone will be entitled to remedy and so on and so forth. But you have to still, of course, you still have to raise issues, because if you don't raise the issues, you'll not be able to know whether there's the course of action. Okay, so the same thing really. Let me just correct myself, because like, how can you know the course of action without you identifying the issues, without you raising issues? So you raise the issues. Then having raised the issues and then having addressed the issues, like stating the relevant law, doing the application and all that, then you are supposed to conclude as whether there's a cause of action, as whether there's a case for which someone can sue, for which someone can take a legal proceeding or not. So not until you've still gone through the usual ARAC, let me put it that way, you will not be in a position to conclude whether there's a cause of action or there's no cause of action. Because if you say that, okay, the cause of action is a breach of contract, what made you come to the conclusion there's a breach of contract, right? If you say that the cause of action is taking an action for rescission of the contract, what made you come to that conclusion? Is it because you've identified that there's a vitiating federal misrepresentation or whatever? So you still need to go through. You cannot just answer that rubric or that task, state the cause of action and just say state breach of contract or this. No, that would be too mechanical, and you'll be behaving like a magician without doing the normal legal analysis. Raise the issues, tell us the relevant law, and then you apply it. So in a sense, it's not really different. It's not really different. Then state the remedy. Yes, a remedy. I always tell my students that when we are dealing with the contract, especially, regardless of the problem type, you will not be doing a bad thing after doing everything, even the advice part and all that. You also tell us what remedy is available to whichever party that you ask to advise and all that. So, and sometimes you may also be asked as whether there are defenses available to the other party against whom a course of action may be maintained. Then you also try to play the devil's advocate from the other side, if there are any defenses that may be canvassed in that particular person's favor. Mr. Jamfi, Ajua, Mr. Bill, and Mr. Ezekiel, if you have some additional points on this particular aspect of the question by Sechibia before we move on.
Okay, Doc. So let us assume that there is a question on, let's say, I'll give some facts. Kofi promises to marry Amma, and that he goes to his Amma's parents, do a knocking ceremony and all that. Subsequently, Kofi impregnates Fia, and he indicates his intention not to marry Amma. Now, if you have such a question and they ask you, so these are the facts. So they say state the course of action. So whether or not Amma has a course of action against Kofi will be all right as an issue. So when you state that, that is where you come to discuss breach of promise to marry. So when you discuss breach of promise to marry, that a breach of promise to marry is an action that entitles a party to an agreement to marry, damages and all that. You state the ingredients. Now, and they will ask you, what are the remedies available to her? Then you whether or not Amma is entitled to some remedies under law for breach of promise to marry. So then you state the remedy. Remedy, definitely, she's entitled. Damages is all that, because the court cannot order specific performance of the marriage. So it's damages that she'll be entitled to. And whether or not there are defenses that you stated. So a defendant may rely on, so the defense will be insanity, bodily infirmity, or all those ones. So you see that in essence, you have gone back to the IRAC that Doc indicated. So whether or not there is a course of action, yes, there is a course of action, which is a breach of promise to marry. Then you come to explain what breach of promise to marry is. So I'm just doing it for breach of promise, but it can be any other topic in law. So you do it the same way. You state the remedy that she'll be entitled to if she succeeds, and the defenses available to the other party. So basically, since the question gives you those clear lines, you can discuss them in the manner earlier indicated.
You're right. Thank you very much. Is there any other thing from any of my panelists? Otherwise, we move on to Naomi's question. Naomi's question was, if you are asked to address legal issues, you are given a problem or scenario, and instead of you being asked to advise the parties, which is usually, or advise someone, which is the usual approach, you are just simply asked, address legal issue, or sometimes they may even say that identify and resolve all the legal issues. That is another way in which that may come up. Of course, when it is that way, you still have to do the IRAC. You still have to do the IRAC. You still need to raise, issues. You identify your area, raise the issues, you take the issues one after the other. Then you tell us the relevant principles, the corresponding authorities, you do the application, the analysis, and then you conclude on that issue, you move on to another issue, you do the same thing. Then, when you finish, in your conclusion, instead of you going to do like the advice, which will have been done in the usual thing, the conclusion will just be pulling everything together and say that in the light of the foregoing, the legal issues as noted are the following. And then just give us the direct answer. In other words, the direct responses to those issues based upon the analysis that you've done, and then you are done. So the difference will lie in the conclusion. So the conclusion, instead, if it's an advice, is instead of maybe saying that I will advise A or B to do X, Y, Z because of this and this and that, you are going to achieve the same thing in a different way. Say that the legal issues which arise from the scenario based upon the foregoing may be summarized as follows. Then we just summarize them. And then to each of them, you tell us the direct answer. That is all. And then you are done. I don't know if TK and my other panelists have additional inputs. Otherwise,
Look, you have stated the point, so there is no need for me to.
Okay, thank you. Okay, so we come back to Ivy. Ivy raised a question: if the president makes a declaration outside Ghana, does it bind Ghana? I think your question, if I understand you, raises the issue of the relationship between international law and the constitution, municipal law, international law. You know, Article 75 of the Constitution, which governs execution of treaties. And you know that Ghana is what we call like a dualist country, not a monist country. A monist country, as you remember, where treaties and international instruments which are signed or ratified are self-executing, they're immediately binding within the domestic or the municipal system. But Ghana, we don't follow that. We follow what we call the dualist approach. And that means that when treaties are signed, international instruments are signed, they don't have immediate or direct effects or applicability within our national law. They must go through processes of domestication or incorporation. So if we look at Article 75, Article 75, Clause 2, that the treaty, agreement, or convention executed by or under the authority of president shall be subject to ratification by A, Act of Parliament, or B, a resolution of Parliament supported by the votes of more than 1/2 of all members of Parliament. So if the president makes a declaration outside Ghana, so long as it is a form of like a treaty or convention and so on, it must be ratified by Parliament, either Parliament passing a legislation which will incorporate that into our law, or passing a resolution by the what we call like the not less than 1/2 of all members of parliament. So once we have that, then that will have like the effect. So let us keep that in mind. Yes, Mr. Jamfi, any addition to this particular aspect of the question? I think we've lost. I think we've lost Mr. Jamfi.
Okay, I'm here.
Yes.
I said that.
Yeah.
I'll add that Asari versus Attorney General gives us an indication, because in that case, the court stated that even though the president may be away, he's still president of the country. So if he makes any declaration outside, it doesn't mean that he ceases to be president while he's outside and someone is acting. He's still the president. So in that case, it's binding on us if he takes, if that decision is what he wants to implement, it will be binding on us, depending on the ratification by Parliament of the necessary legal mechanisms. All right, sir.
Okay, thank you. Now I think the last question has to do with the same-sex marriage. The person asked the question, same-sex marriage. I think the last year, the issue of a same-sex marriage gained a bit of attraction, and because of the private members bill on the LGBTI++ legislation. So as came out evidently, I think last year, I think there was an article on the subject by Professor Tukuba, which I made students look at, in which he made some points. Although I don't agree with all the points, but it's a very good article in which he tries to make the point that if we look at our law as a currently stance, most of the things that are classified as the LGBTI and so on, they are not necessarily, if you like, outlawed, or they are not forbidden by our law. And he gave a very nice illustration and analysis of what it is. And then the point was made that like maybe oftentimes when we talk about the LGBTI, our mind just goes to unnatural carnal knowledge, as maybe people having maybe a man and a man having an access or something like that. But then there are so many other sexual behavior or manifestations which could properly be treated as being what is considered as an aspect of the LGBTI++. And yet our law as it is now is strictly considered and construed, do not appear to actually frown upon that. Yeah, but you look at Article 33, oftentimes people point to Article 33, clause 5 of the Constitution to try and make the points. And if you look at Article 33, clause 5, we have the provision that the rights, duties, declaration, and guarantees relating to fundamental human rights and freedoms, specifically mentioned in this chapter, that's chapter 5, shall not be regarded as excluding others not specifically mentioned, which are considered to be inherent in a democracy and intended to secure the freedom and dignity of man. So some people may, for example, allude to this provision and try to argue that if in some established democracies, and even on the African continent, you cite some examples that they have decriminalized, if you like, what was previously considered the sodomy, or national canon knowledge, and so on and so forth. Then it stands to reason that our constitution does not appear to have outlawed LGBTI and so on and so forth. But again, I will say that this is an issue what is also jurisprudential. Remember, the UK, following the offending reports, if you remember your criminal law and the famous deviling debates on whether the state can actually legislate on the private space. What takes place, for example, between adults in their inner sanctum of their rooms and so on. But of course, it's much also beyond that. It's also about recognition. If, for example, same-sex marriage is not recognized, then if you take interstate succession law, which makes reference to a spouse, if you are not in a heterosexual marriage, then there's no way that you can bring yourself within the reference to a spouse. And despite the fact that, to all intents and purposes, you might have been living with someone for many years and all that, should he or she die intestate, the law will not accord you the necessary recognition and so on and so forth. So it's much more than just the sexual act, and oftentimes the emphasis is just placed on the sexual act when we are looking at the LGBTI. Yeah. So something like that, if you are going to get a question, it will be a question which is quite open and will require you to bring your appreciation of, first of all, your awareness of the criminal law in relation to what do you call the national canon knowledge and so on. And then you come back to the broader jurisprudential and philosophical issue of the relationship between the state's attempt to regulate the private sexual preferences, and also implication on some people being excluded from recognition of their right and certain interests and all that. And at least you must also be mindful of Article 33 clause 5, and also the fact of the article. If you look at the Article 40, right? If you go to Article 40, if I'm not mistaken, let me take my question. If we go to Article 40 of the Constitution, for example, it talks about the fact that in dealing with other nations, the government, that is the government of Ghana, shall promote and protect interests of Ghana. So, for example, you can make argument on both sides, right? If you want to make argument that the LGBTR is really not protected by our constitution and seems to not be recognized until maybe during the Constitutional Review Commission in 2010, if you look at our report, we said that, well, that should be left to interpretation by the courts. But as we speak now, I'm not aware of any direct judicial pronouncement regarding whether LGBTI rights can be considered as forming part of the compendium of rights, which are protected explicitly or indirectly through Article 33 clause 5 of the Constitution. If you wanted to play the devil's advocate, you could also, for example, make reference to Article 40 clause A and say that, yes, the Ghana's interest, which is alluded to, also refers to what we are customarily used to as a people. The fact that in our customary communities and all that, there's even a reference to dehumanizing, practices and so on being outlawed. And within our customary practices, same-sex relations, for example, was seen as a taboo and people could be ostracized and so on and so forth. So if that is the case, an argument could be made that within our traditional society, there is no recognition for that. Then you can also play the devil's advocate by also referring to the fact that Ghana, we are not an island. We are in a community of what? Of various nations. So long as we open our borders to people to come here, the other challenge is that if somebody is coming from a country in which his status as LGBTI, for example, is recognized and is lived there many years and so on, why should the person come to Ghana? For example, now that we have the secretary of the AFTA here, another international organization, the person comes to do business and you say that because your country you don't recognize LGBTI, a status which is properly recognized in his country many years, and he's done so many things with it, you want to just strip him or ignore that. So these are some of the, so I would like you to be very intellectual rather than being emotional or being just religious about it. This is a law paper. This is not what they call the emotional, it's not a religious paper. So you have to think very objectively from both angles. So we don't have right and wrong answers. We can only have what we call like a more persuasive based upon the logical reasoning that we deploy in this type of question. So those are the views I will express with respect to Ivy's question. So I will yield to Mr. Jamfi and my other colleagues if you have any other input with respect to this question before we end.
Okay, you've dealt so masterfully with this, especially with the addition. I just read that Article 40. And if you want to play the devil's advocate again, Article 40C, also, because Ghana is not an island on its own and we have to respect, it says that in its dealings with other nations, the government shall promote respect for international law, treaty obligations, and the settlement of international dispute by. So when it comes to international law and treaty obligations, Ghana is signatory to most of the human rights matters that recognizes gay the LGBT. So if we have to respect all those ones too, yes, it means that you have to discuss it as such. And except to add lastly that no discussion on this can be had without Section 104 of Act 29. Yeah.
Right.
Act 29. So that one too must be noted and studied. So you look at Section 104 as well, natural canon knowledge, as Doc earlier alluded to, because that is part of, and you can refer to some of the sexual in the essay if you are writing, like some of the voyeurism, sadist, and all those ones, at least just to indicate that you have a grasp of that subject matter.
And
thank you.
Yeah, thank you. And because of that, that's why I said that Professor Tuguba's article is very interesting, because he actually outlines all manner of sexual expression other than the conventional, if you like, sexual intercourse between the heterosexual, which you may want to point to. And so that is very interesting. You can look at that. And then if you're also interested in knowing more about, when the LGBTI legislation came out, I did a lecture for St. Gregory Major Seminary, and the lecture was centered on the bill. And I think I discussed a number of points. I think it was recorded and it's on the Ghana Law TV channel. So if you search, you find it, you can play it and get some more points, and all these things I have considered them as well. Okay, so time is fast spent. We'll be here more than 2 hours, and we have to draw the curtain down. I'd like to thank my panelists, Mr. Stanley Tribu Akodua Jamfi, Mr. Kojo Bio Ejei, Mr. Ezekiel Osei, Ajua Asamoah, and we'd like to thank you for your time and your contribution. I'm sure that our students will certainly make you proud. We're going to write well and pass so that they'll be happy and they'll not come and sit in this class again next year. Next year, you don't want to see any of you who join us here. May the Lord grant it that none of you will have the, the basis to join this class again, because we want you to go to class and pass once. So if you believe,
Amen.
Amen. Dog, but dog, we still don't know the pass mark. Dog, we still don't know the pass mark.
See, when we are making the prophecy, we're talking about the pass mark. Why should you worry about pass mark? Just believe that you are not going to write it again. That is all. So thank you. So tomorrow at 5, we have another session with Dr. Abdul Bamba Basit. So thank you very much and good night.
Good night, Reverend.
Good night. Thank you.
Good night.